rise. The Court of Appeals Division 1 is now in session.
Thank you. Please be seated. Good morning. We're here for oral argument in the matter of Susan Wellman versus Greg Waits. That's case number CACV17-0251. I would remind you, counsel, that these proceedings are arguments being video and audio recorded, so please identify yourselves and your clients at the beginning of your argument. Appellant's counsel, you have 20 minutes in which to, each side will have 20 minutes, and the appellant's counsel, if you watch the clock, and reserve as much time as you wish for rebuttal, if any. And also, please keep in mind that we've read the briefs and have discussed the case, this case in conference. With that, counsel for appellant, you may proceed.
Good morning. May it please the court, my name is Mark Shields. I represent the appellant mother, Susan Wellman. I'd like to start by pointing out a few specific notes about the order that brings us here today from March 2nd of 2017. It's a child support order, obviously, as this court knows. Beginning on page 2 of that order, the authoring judge begins to quote directly, extensively, from ARS 25809B. That continues on to page 3. Pages 3, 4, and 5 also discuss 809B. Page 3 quotes ARS 25320C, and page 5 further discusses 320C. Now, what is glaringly absent from any of these quotations and any of these discussions by the trial court? The statute that actually applies, which is 25809A. This, I think, is very telling about the court, about the decision, because here is the statute that matters, and yet it is the statute that is conspicuously absent from the trial court's analysis.
Counsel, let's take up a procedural issue. If I have read the record correctly, in the joint pretrial statement, your client said, in essence, that 25320, ARS 25320 is the controlling authority in this case. How do you back away from that on appeal without running afoul of general waiver principles that this court often applies?
Well, the first thing I do is I exercise my duty of candor to the court and acknowledge he was wrong, and the trial court specifically found that he was wrong. Therefore, we have an acknowledgement that the statute simply does not apply. Now, as I understand it, as I understand what the court is getting at, the same question I have asked myself would be a principle of waiver. Now, what do we waive? We waive affirmative defenses under the law. Before this court, we waive arguments raised in the reply brief for the first time. There are all sorts of rights or objections that can be waived, but candidly, Your Honor, I'm not aware of any authority that claims that we can actually waive the law. To me, that would be akin...
Understood, but you can waive arguments. It's my understanding that the argument, and you can correct me and clarify, that's what we're here for, is that your argument is that the Superior Court here had zero discretion, no discretion. The court was absolutely obligated to award 3 years of child support in addition to what was ordered. I mean, the court needed to do that under 25809A, correct?
And there is some discretion on that. We'll get to that point, though.
Well, with equitable defenses, I suppose. But
correct.
But that's not what was argued below. What was argued below, from my reading of the transcript, is that there was discretion. In fact, that was stated in closing arguments that Your Honor has discretion, and then that together with the reliance on 25320, I just don't see that argument that you're making now was made in the Superior Court to give the Superior Court that opportunity to think, oh yeah, maybe I do not have discretion here, and I need to look at. And is that fair to the Superior Court?
I believe it is fair to the Superior Court because on page 2. The trial court does acknowledge 25809A. He was put on notice enough that it's there. Did he rely on it? Did he follow it? No, he followed a statute that simply doesn't apply because we weren't asking for 3 years beyond that. But I will reiterate, Your Honor, in my research, I have not found anything holding that a client or a litigant can waive the law that actually governs. If it's a defense, that's a different story. This is not a defense. This is the governing law.
Counsel, let me
it would
ask
be
you.
akin
Let
to
me ask you a
subject matter
question.
jurisdiction. I apologize, Judge.
No, do I hear you right? Because I want to make sure I understand your point on waiver. That counsel in front of a party through counsel in front of Superior Court can argue that Statute A applies throughout Superior Court proceedings, never saying there's a distinction to Statute B. And then for the first time on appeal can argue, no, Judge. The Superior Court got it wrong. Statute B had to apply. Notwithstanding what we said, notwithstanding months or, in other cases, years of litigation under Statute A, that we can start all over and sort of get a test run on Statute A and then argue here that Statute B had to apply?
I think the bottom line issue in that, Your Honor, boils down to the trial court's duty. The trial court's duty is to apply the law. And the law that applies is what is set forth here. These parties were never married, which the trial court acknowledges.
Your point, but when I guess your argument is waiver could never apply. Why wouldn't a party just sort of see how they do under Statute A, under your view, and then come to us and say, well, no, notwithstanding what we said or didn't say over a course of years, it's really Statute B, and so you have to send this back?
Well, I would first point out under that analysis that the statutes are not that dissimilar between 320 and 809. They're not markedly different. We're still looking at a situation where child support was owed but never paid. The difference is 320 looks at a totality of circumstances. The judge read something similar into that. The totality of circumstances in a paternity case really consist of whether the parties actually live together, as was the case in Petro versus Giannini, why we were looking at only 33 months there instead of 36. Those would be the totalities of circumstances. I don't believe that it's so dissimilar that it creates a sort of legal crisis on the Superior Court's part, but I do believe that the Superior Court is obligated to apply the law that does actually apply, and I confidently state to this Court that is not what happened.
Let me ask you then, because the point you make, which I think is reflected in the pretrial statement that Judge Brown referenced, raises sort of a subsidiary point. Are these statutes different, or are they not different?
They are different in some respects, and they are similar in some respects.
Let me ask a better question. Are they materially different for purposes of our appeal?
For purposes of the appeal and considering they are materially different because 809A contains the directive shall. In terms of the other circumstances, we're still applying the same child support guidelines. We are still looking at the surrounding circumstances, at least with respect to the child support guideline calculations and whether the parent actually supported the child. Now, there are some other considerations that flow over into 809B. That's what the trial court actually ruled on. Those circumstances are very different because they do not apply. The discretion is marked by a few words in the actual applicable statute. The first, as I stated, is the word shall. The court shall apply the guidelines. Obviously, that's the same. And then direct past support. Now, interestingly, the trial court did look at that term past support on page 3. And he stated, well, this statute doesn't give me explicit guidelines whether to award past support. And on that note, I respectfully disagree because the statute contains the word shall. Now, that sets the discretion. What limits the discretion or what directs that discretion, those would be the equitable defenses. And Judge Brown, I apologize if I cut you off earlier on that. That is the discretion that's involved under 809A. There were no equitable defenses pled or found. We know very clearly from established law that those equitable defenses have to be found by clear and compelling evidence. There is no such finding. The words latches, estoppel, waiver, they never appear anywhere in the pleadings that I was able to find. They certainly don't appear anywhere in the trial court's analysis.
Maybe we'll come back to equitable defenses in a minute, but I'd like you to turn to the precise language of the statute. I'm looking at A and B, and I don't see anywhere in there where it says the court shall award 3 years of child support.
I would direct the court on that note, first of all, to the Petro versus Giannini decision that was cited under Rule 111C. That takes it as the given. Now, where we take this,
I've read
we
that.
take the word.
I read it, and I know that our first duty is to
Thank
read
you.
the plain language of the statute and see if we can't understand what the legislature is saying.
And our plain language in this case includes the word shall and past support. Now, what would past support be?
Well, true,
It's
no, I
clearly
understand.
not.
And here we have an award of past support.
We have an award of, I beg to differ actually, because looking under B, this is where the trial court and said that, okay, well, we have to award it between the period of commencement of the proceeding and the date that child support is ordered to begin, the date we actually get to trial, okay? That is not referred to as past support. The legislature did not use that term with respect to that period here, and that's part of where the trial court began to err. The presumption of 3 years actually does appear in 809B, and that we get into the 809B analyses when we're trying to go beyond 3 years. And again, the record's clear. Mother at the time of trial was not seeking to go beyond those 3 years. So admittedly, we do have to look to 809B to get the full context of 809A. What we do not get out of that analysis is applying these 809B factors to 809A. Our 809A analysis is limited almost purely to equitable defenses. And again, we don't have those. I think that the terms past support, I spent a couple of pages pointing that out in the opening brief, are very instructive in helping in that. But the specific award of which the court was speaking is from the time of filing forward. That is not past support. You know, if we took that and relied on that as past support, it would render the term past support used in A and in other sections superfluous, meaningless, perhaps even contradictory. Now, I want to point out also a great deal of where the argument falls apart, I believe, in response to this. The first several pages of the answering brief go in to describe what I will call simply fault. They try to place fault on mother. They try to make her look like a bad person who wants only money. This all about money. You're going to see that quote in the record multiple times. That's what child support is. It's money. For father to claim that it's all about money to mother simply makes no sense, because we clearly know it's all about money to him. He doesn't want to pay it. Can this court imagine the chaos, the inequities that would result if we allowed a desire for money to be an established equitable defense to a child support order? We don't have that luxury. I apologize. Luxury is the wrong word for it. We simply don't get there. I would point out also, if there is any consideration of an equitable defense in there, even though it clearly was not pled, not found by the required clear and compelling evidence.
Let's kind of circle back to waiver on that. Did your client put the father on notice here, clearly on notice, by pleading 809? I mean, because the absence of 809A, did your client nonetheless put the father on notice that he should have pled those equitable defenses?
I will check the original filing, but I believe the original filing did request child support clear back beyond that 3-year period, which would clearly place this.
But not under 809A.
It would have been under 809 period. The equitable defenses, what he was trying to establish, were his own made-up equitable defenses. Frankly, I'm just being candid with the court on that.
Shifting gears just a second, because you said that the statutes are similar earlier. 320C and 25809 are similar. And yes, those factors under 809B the wording seems similar. Why? But not identical. Why would the legislature leave these under 320C? It's discretion, right? Whether to award. Would you agree with me? There's discretion under 320C whether to award the 3 years.
There is discretion.
But
yes.
That discretion is lacking, according to your argument, under 809.
Yeah.
Why the difference there?
Yeah, and I can't answer precisely why. I can give the court a good idea of why, but frankly, I don't think our concern is why exactly the legislature did that. Our concern is that the legislature did that. The best answer I can give, I think it's a pretty obvious one, is that married people typically live together. Paternity cases, the parents typically do not live together. If a parent is living under the same roof with a child, that parent is presumably supporting the child, and that's why we have the ability, or in this case, the requirement to go back to make sure that the paramount concern, which is the child's best interests, is supported. I'd like to reserve the remainder of my time for rebuttal.
Okay. Thank you.
May it please the court, Keith Berkshire for the appellee. I think one of the things that you ended with, Judge Brown, is where I'd want to start on the equitable offenses. Mother did request a child support arrears of the entirety of the child's life. I think in excess of $400,000 was the number, if I'm correct, but didn't ever state that it was mandatory, as they're now claiming, which under 809A, to say that we didn't plead a defense, well, there's never an allegation that it was an absolute mandatory 3 years. That allegation never came forward until the opening brief. It definitely wasn't the allegation in the pretrial statement where they alleged that 25320C applied. So there was never an argument that the trial court was allowed to hear on this idea that the 809A is an absolutely mandatory requirement of the 3 years.
Well, to that point, the statute does say shall, 25809A, and in fact your client cited 809A in the joint pretrial statement. Ironically, I mean, the other side, the wife took the position 320C applied. Your client took the position that 25809 applied in the joint pretrial.
They did. My client did block quote the entirety of 25809. A,
so
B,
it's a little hard
C.
to claim that you didn't know that shall means shall.
But the position that they took was that the 809B, that what my client addressed was 809B, that there was always a defense, that it was the same defense essentially that's allowed under 320C, which is this is discretionary. The court has to look at what actually occurred. Did the parties, the criteria that you were just discussing in 320C, what was the conduct of the parties, what was the reasoning they didn't effectuate service, and so forth. While I understand that counsel wants to ignore the facts here, I don't know if you can really do that. This is the definition of essentially legal game playing, of saying I'm going to file the second before my time expires, right before the child turns 18. We're talking, I think it was 6 days before the court lost jurisdiction. That's what the court looked at. What the trial court looked at was the motivations behind the parties and those types of things when it denied mother attorney's fees, when it dealt with the claims and basically their credibility on top of that.
To that point, was it proper to consider mother's reasoning or the reasons why she didn't bring litigation forward until just shy of the 18th birthday in determining attorney's fees?
I think it is. I mean, it's the reasonableness of the positions all the way around. You file a paternity case with custody and other things.
Isn't it the reasonableness of positions taken during litigation?
Well, I think that her position on it, easily considering the fact she wanted 18 years of child support, and if you look at her initial petition,
well,
the
that's
fact
before
that
when she was pro per.
Well, and the court also looked at the fact that she turned down offers of, she herself made an offer of, I believe, $65,000, which my client, I was not trial counsel, but my client accepted, and then she withdrew it. So I think there was a totality of the circumstances of reasonableness.
Weren't there some intervening facts? I can't remember exactly, but it wasn't offer acceptance and
correct. I think it was
offer.
After there was some other litigation and so forth, but it was still an amount, a significant amount offered by mother. I'm not going to say there was a contract because there wasn't, as you stated, an actual offer acceptance contract that we could point to, but the reasonableness of turning down $65,000 was looked at by the trial court as well. I mean, this is there was definitely evidence of reasonableness. There's definitely evidence of the positions taken in that were credibility determinations for the trial court.
In the course of litigation?
During the entirety of the litigation, correct.
Right. Okay.
So, and I would agree to some extent that the equitable defenses were not pled as specifically as possible here. They weren't, as in a normal civil complaint, you list the equitable defenses in the last paragraph. However, they did make the claims. They did make the claim that you waited too long, you gave up the right for me to have any parenting time, legal rights, and those things. The court also made those findings that mother did this because she didn't want to have a custody dispute. She testified, I didn't want to have a custody dispute this time. I was already going through another one. That she testified that she always knew where he was, knew where his parents were, and these types of things, that she never failed to, he never evaded service and all those types of things that were essentially not only equitable defenses under latches, but they were defenses under 25320C. One of the things that I think, and again, we're raising this basically as an as-applied constitutional issue, is I don't know how you put these separate. This court would essentially have to say that paternity fathers have an automatic judgment against them. There's, as we're going to argue later, suspect classes and so forth in these things. This is, unwed fathers have been repeatedly held to have to be at the same legal standard as their wed counterparts. Reading it as mother requests specifically contradicts that. It says paternity cases, automatic 3 years, no questions, only subject to equitable defenses. Reading 320C is only applying to marriages, says, no, those defenses are automatic. It's not even the higher standing of clear and compelling that you'd have to apply for equitable defenses. It's, here's what the court shall consider. It's not a shall, it's you can, once you consider these factors. There's no presumption either way versus how mother is trying to say that 809A applies, which is mandatory all circumstances unless you have clear and compelling for the equitable defenses.
Do you think 320C should be read as only applying to marriages?
No, I don't. I think that if we look at the legislative history, the limited stuff we have from the speeches on the floor or whatever in it, they were trying to make the two match. So 320, I mean, the purpose there was trying to make them specifically match. And you look, actually, it was attached in the appendix to the reply. There was the printout from about who testified about what in that. And everybody that state testified, including the sponsor, Bill Brotherton, was we need to make these match because it's unfair. They were actually going the other way, that at the time it was unfair that you could go retroactively in paternity cases and couldn't in marriages. So they were stating the addition of 320C was saying they have to match. 809 has to match 320C.
They stopped just short of doing that perfectly, though, didn't they?
The legislature stops short a lot of times on perfect wording. But I think the intent there is we were trying to make them equivalent. I mean, Bill Brotherton specifically stated, or Senator Brotherton, sorry, specifically stated that it's unfair that you can do this in paternity cases and can't in marriages. So I think the intent there was to make them, coincide. But again, I think it doesn't get around the point that 320C says in child support proceedings. I think the irony here is mother wants, 320 to somehow be only in marriages. 320 is the child support guidelines. I mean, that's Appendix A. 25320 Appendix A is the child support guidelines. Every factor for child support is 25320. So to parse out this one section and say that we know that the guidelines, I mean, the number of times we reference 25320 in the trial court is every single case. But to parse out this one section and say that doesn't apply in paternity cases, I think misinterprets reading the statutes together, because that is it's just the child support guidelines. It's like saying 25319 isn't spousal maintenance. Well, that's what the actual statute is. It's the child support guidelines.
There was a more direct way to do that, though, in 25809 that was a path that was not taken, and that's what results in this struggle. I mean, if they said, look, in paternity cases, here's what you have to do. Oh, and by the way, look to 25320. It's sort of game over, right? That's the easy answer.
I think so, but again, 320 was latter. It went, A existed, then they added 809B, and then they added 320C. So I think sequentially I would agree with you, but that's just not how the legislature chose to. I mean, 809 has been around for a long time, and so is 320, but 320C is by far the most recent, and I think that's why the legislative history is important to use to interpret the rest, because that's the most recent change that we have to this retroactive idea of child support. And I think this is what the trial court did. I mean, while the trial court did apply 25809, the trial court clearly looked at 320C, and the trial court specifically said, which I believe is correct, that 809 doesn't give really an analysis of what to do during these 3 years. When A existed only, it was mandatory. Then they add B, and B doesn't say what to do during that period. It creates this, you can't go back farther, but it doesn't say, and it creates a absolute mandatory since the date of service of the petition. But it doesn't say absolute mandatory for 3 years prior to the service petition. It could have. When they added 25809B, instead of, which is the more recent part of 809, they could have said it's absolutely mandatory for the 3 years prior, unless you have equitable defenses during that period, or forward, it's absolutely mandatory. But that is missing. And that's why I think that when you look at 320, it fills in the gap of what the legislature intended during this 3-year period. One last thing on the equitable defenses here. Because of the facts, and the court did make some very specific findings on mother's intent in this, I still would argue that the laches concept applies, that unreasonably delayed in bringing the case, and the other party was prejudiced. Well, the prejudice wasn't necessarily, let's say she filed it at age 12. Her argument would still apply about the 3 years. The prejudice is the other issue that was pled, which is the custody side of this. Waiting till immediately prior to 18, anybody that she went and saw, any attorney, is going to say, well, yeah, he has no rights to see the child, because by the time you get into court, we've lost jurisdiction over the child. That's the prejudice for the laches argument. And the court specifically dealt with that, and there were questions about it, and both parties testified about it. And my client specifically testified about, I couldn't do anything once she filed this. So there's...
Could he have done something sooner? Obviously he could.
Well, obviously.
I mean, doesn't the prejudice lose a little bit of weight when he could have done something for 18 years?
I think anybody could do something for 18 years, Judge, but he isn't the one that brought the case. She did it knowing that he couldn't. There's no chance that she didn't know he wouldn't have any rights to this child. She testified about it, that because of the delay in this, that I can get child support with no risk to me of losing any parenting time with my child, no risk of any of this, custody litigation that she testified about that she didn't want, that she was going through at the time when this child was born. So while he could have, he didn't file the action and do the delay with a harm to her. She did that with a harm to him in the delay of this. One of the things that...
What again is the harm to him?
The fact that he could never petition, or that he couldn't turn around and cross-petition for custody or parenting time.
And that's something he could have only done if she initiated?
No, obviously he could have, but the procedural way she filed on this prevented him from having this other claim against her. I'm not saying he couldn't have done it, Judge. Obviously he could have.
Different from a case where a father has no idea that there's a possibility that he may have a child out there.
He did testify that that he wasn't sure, didn't know what the child was, but admittedly the court did find that he probably knew. So I'm not going to contradict what the trial court found on this, because that would be a credibility issue. But that is the harm that suffered. You can't say there was no harm. Most people that file child support know that the first thing that's going to happen is that the other side is going to file a request for custody. You can't say that there's no, she forewent that harm by filing at the last minute on this.
And isn't the other side of that coin that he forewent the harm of having child support tacked on him by not seeking to visit?
It could be. I mean, it definitely went both ways, that they both waived something that they theoretically had a right to. The difference was hers is attempting to survive. And I don't think that 809A is even read in Petro. With all due respect to the panel on that, I don't think that the reading of that is correct from the standpoint that this is an absolutely mandatory requirement under A. But even if it was, as where this court started today, they never pled it. They never requested it. They never said this is an absolute mandatory. It would have changed potentially the way my client dealt with it in the trial court, because that claim was never pled that this was mandatory. They're the ones that said they're subject to defenses. They're the ones that said you look at the ideas of who sought out who, did you evade service, what are the other remedies. This was never pled as mandatory until the opening brief. And I think that is obviously one of the biggest issues in this case, is that we never had a chance to deal with it at the trial court from that level. My client's trial counsel had always dealt with B, agreeing that the factors of B are the same as the factors they pled in 25320C, which are you look at the surrounding facts. No one ever raised this from A as being an absolute mandatory requirement. That only came up on appeal, which I believe is waiver. Unless the court has anything else, I'll...
Thank you.
There were a few points that came up in Mr. Berkshire's argument that I think brings some points from my original argument full circle. First of all, Judge Brown and Judge Thuma both had questions regarding, is this basically fair to the trial court? Was this properly pled that 809A applies? Looking at it from the perspective of fairness, I pointed out that the trial court did in fact cite 809A, although it did not quote 809A. The trial court clearly knew 809A existed. Is it too much of a duty to expect a superior court judge to apply a law, or at least to analyze the law that he cited? No, I certainly don't believe that's an unfair burden. I believe that's the actual duty of the trial court. Now, what came out further in Mr. Berkshire's argument...
What's the duty of an advocate in that circumstance, then?
Well, the duty of the advocate, again, I think comes back to what is fair. The duty would be to put someone on fair notice. That question, I believe, was plainly answered by looking at page 7, the unnumbered page 7, as I pointed out, of the pretrial statement. 809A is clearly quoted by father. They knew what was going on. They simply chose, they followed the same trap that happened in the Petro case and that I suspect happens in many other cases. They don't delineate and follow the law that actually applies. When we do that, our bottom line question is answered. There is no question that both father and the trial court were on proper notice. That brings us back to the equitable defense. Now, what I heard that was most interesting to me from Mr. Berkshire's presentation was that, well, we would have worked things differently with respect to our equitable defenses had A been more front and center. I believe that argument is completely belied by the answering brief, because the answering brief says, no, we did plead equitable defenses, and the court did find equitable defenses. Obviously, I take issue with that, but now they simply can't have it both ways.
Well,
they can't say we would have.
As I heard it, was that they weren't informed of, and I understand that counsel, at least as I understand it, is for both sides is different than trial counsel. Is that
that is accurate? Yeah.
So I understand you take the case as you find it, but I thought I heard the argument that they weren't presented with an argument that 809A was mandatory.
The statute says what it says. They quoted it. I don't know how they can be held to the standard to say, yes, I quoted it, but I didn't follow it. No, we practice law. We're charged with knowing the law. I have been candid with the court in acknowledging.
And that may come back to my question before that I think I understand your position that you've pointed to opposing counsel and to the trial court not doing what you believe they should have. I think the question I have is about your predecessor citing the 320 as opposed to 809A in the final trial management statement. And we've talked about that, and I understand your position.
Let me bring that back full circle, though, if I may. This is an extraordinarily thorough attorney who stands by my side here, who just got done addressing the court. If there were any case law holding that the governing law is somehow waived because the trial attorney cited the wrong law, we would have heard it. Mr. Berkshire would have found it. I would have found it if it existed. Neither one of us has found it. It does not exist. We are bound by the law. There is a question, a concern about whether there was enough notice given to bring the trial court and opposing counsel into proper notice territory about the governing law, and I believe there clearly was. Judge Cruz touched on an attorney's fees issue, and I do want to touch on that in the remaining time I have left. This court is much more accustomed to seeing my name on briefs than it is to seeing my face in oral arguments. There's a reason for that. This is expensive. I typically represent the more economically challenged person. That is true in spades in this case. We have a man with, I believe it was litigated, $24,000 a month of income on the other side, several times more than my clients. Now, that alone gives an overwhelming consideration to an award of fees under 25-324. Judge Cruz specifically looked at the other factor of the fee statute, which is reasonableness. Here we have a trial court analyzing all these things that I finally did hear an admission of 10 minutes into the argument are not applicable. They are not applicable. We know the wrong statute was looked at. And I submit, along the lines of what Judge Cruz inquired about, that if these questions are not applicable to the underlying law, they should not be applicable as reasonableness under 25-324, and they are specifically what the trial court found. The other problem with it is that I think was pointed out with some nods by all three on this panel. Every argument that father raises for a quote-unquote prejudice or unreasonableness, except the final, that one settlement negotiation that got in there, applies to dad. He was free at all times to file. Why was it unreasonable for mom to wait to file when dad never filed either? Everything that was in fact held against mother under 25-324 in that category was at least as equally applicable to father. My time is up. Does the court have any more questions for me?
No, Counsel.
Thank you.
Thank you both for your arguments this morning. The court will take the matter under advisement and issue a decision in due course. It will take a brief recess to prepare for the next argument.